My name is Carrie Uva, and I'm a local attorney here in the city of Downey. And I'm also a real estate broker, and I'm a member of the Downey Association of Realtors. I'm here today to do a presentation for you on probate and living trusts. So we're going to get started. Our first slide talks about how is a probate started. Probates are started by the filing of a petition in probate court when somebody passes away. Now, the probates do not need to be started immediately after someone passes away, and the family can decide basically when they're ready to start the probate process. There is no rule or law that says it must be done immediately upon someone passing away. What happens when someone files a probate action? They will be filing a petition with the probate court, and if they have a will, they will still have to file their petition in probate court. If they don't have a will, then they file the same petition in probate court. If they do have a will, the probate court will follow the terms of the will and distribute to those named beneficiaries that are mentioned in the will. If they don't have a will, then the probate court will distribute the estate to the heirs at law, and that will be determined throughout the probate process. The purpose of the probate is to make sure that the debts of the decedent are paid and that the property that the person who passed away gets passed on to their heirs. In the next slide, we talk about how is a probate started. The petition, which is a legal document, gets filed in the probate court of that jurisdiction. A bond must be posted unless there's a will and the will says that no bond is required. There must be a publication in a local newspaper that this individual has passed away. And then the final, one of the first steps, final one, is that a property must be appraised. And through the probate process, that's done through a probate referee, which is similar to what we know as a real estate appraiser. So those are the three things that must be done, four things, excuse me, that must be done to start the probate. A petition must be filed in the probate court. A bond must be posted with a bonding company. They must publish in a local newspaper that the person has passed away, and that the real property and vacant land must be appraised. All right, next slide. What happens next? That's pretty much a waiting game now. So once all those four things are done, we have to wait for the court to issue letters of administration. Usually that takes anywhere 2 to 4 to 6 months. In the era of COVID that we've just gone through, it has taken quite a bit longer, but the courts are now starting to get things more back on track, so it shouldn't take as long as it has during the last year. The administrator of the estate or the executor, they can't do anything. They don't have any power until those letters of administration are issued. Once the letters of administration are issued, then the administrator or executive does have the power to do things such as selling the property, doing things with the estate that need to get done, because now the court has given them power to act. Okay, next slide. What are the costs associated with a probate? Probates can be a little bit on the expensive side in all reality. So there are statutory fees that an attorney will get paid at the end of the probate, and also the executor of the estate, if they choose to, they can get paid for their time and service as the executor of the estate. Now, it's a statutory fee, means it's covered by state statute. So it's the same no matter what attorney you hire, what law firm you hire, it's the same fee. And the executor's fee is the same fee no matter who the executor is. So I put here as an example on this first line item, for an estate that's valued at about $500,000, the fee would be about $26,000. And that would be $13,000 for the attorney and $13,000 for the executor. And those fees would get paid at the end of the probate. Some of the other fees associated are the initial filing fee that you have to file for that petition. That costs about $495. You have to pay that same fee again at the time you close the estate. In order to close, to submit a final closure of the estate, got to pay that filing fee a second time. The publication fee, depending on the newspaper that you hire, those of course can range, but they generally start at around a couple $100, $250, and anywhere upwards from that. The bond is based on the value of the estate, so that just depends on how large the estate is or how small the estate is. And then the probate referee, that appraiser, as we know, his fee is based on the value of that real property. It's a percentage of the real property. Generally, gosh, those can range from $100 to $200, $300, $400, depending on the value. So those 4 fees are upfront fees. Those usually get paid within the first 2 to 4 months of the probate, maybe 2 to 6 months of the probate. The very first one, the attorney fee and the executor fee, those get paid at the very end of the probate. All right, next slide. I thought I would bring in something into the presentation about real estate related forms and processes that we as real estate agents kind of need to be aware of when we have a probate listing, and just a little bit of basic information just to kind of help, especially those that are new in the business. When you take a probate listing, you take it at 90 days. So it's not the normal 160 days that we normally take a listing for. So it's a 90-day listing. The commission is statutory, and it's 5% for a single family residence and 10% for a vacant lot. Property is sold as is. Generally speaking, no termite, no repairs, nothing like that. The heirs don't know what the property has, right or wrong. The executor has usually no knowledge. So it's generally an as-is, a true as-is sale. When we do our listing paperwork, a transfer disclosure statement is not required. The seller is exempt from providing that. However, there are a few other CAR forms that should be used, and that would be the probate advisory, the probate listing addendum form. And then when you write up an offer, it should be on a probate purchase agreement. And then of course, the representative capacity disclosure would need to be used for the listing part of it. And in that, you would be disclosing the estate as the seller, and it would be the caption from the legal action as to the legal name of the estate. And if you don't know that, you can always ask the attorney that's handling that probate, and they will give you the name and the title of the estate to put in under that representative capacity. Okay. Next slide deals with offers. When you write up an offer on a probate listing, it needs to be a 10% good faith deposit when submitting the offer. Some attorneys tend to be a little bit flexible on that. The code does say that it should be a 10% good faith deposit, but some attorneys are a little bit more flexible and they will let you bring in less. A few years back when FHA offers were very common, you know, an FHA buyer generally doesn't have that big of a good faith deposit because of the lower down payment, et cetera. So in those days, attorneys were a lot more flexible to allow a lesser deposit, but generally speaking, it's 10%. The deposit is non-refundable. So if your buyer backs out of the deal, that's not refunded back to them. So you need to make very certain that the buyer is vested in the property and they're willing to go forward, because if they back out for any reason, they don't get their money back. It stays with the estate. Two different ways to sell a probate listing. And these are legal terms that can be confusing, but there's something called the Independent Administrators Act. And then the other thing is a court confirmation sale. Those are two different ways that properties are sold through a probate. The Independent Administrators Act gives the executor full authority to make a decision on when offers are presented. They can accept an offer and then open escrow basically. Under the court confirmation sale, the executor does not have that full authority. And so then a whole process has to happen where they do accept an offer, but then it gets submitted into court, and then overbidders are allowed to come into court and pay more for the property. Not going to get into too much detail on that for this presentation. However, if anybody has any questions or anything about this, once they've viewed this video, you can certainly reach out to me and I will help you and guide you through those 2 steps if you need more assistance. Okay, next slide. What is the time frame for a probate case? So the average probate prior to COVID, sorry, our lives seem to be that way now, before COVID, after COVID, but prior to COVID, the average probate took about 12 to 16 months. And that 12 to 16 months was basically from the day that you filed that petition to the day that the distribution was made to the beneficiaries. That was about a 12, generally they were about a 12-month period. Now with COVID, they're taking a lot longer. I had one that was filed right before COVID in March of 2019, and we didn't settle that estate until just May of this year. And that was a very simple estate. It only had 1 property, but because of COVID, when the courts shut down for those several months, everything got backlogged. So generally speaking, it should take about a year from start to finish. That doesn't mean though that you can't sell that property prior to that 1 year. You can. During that 12 to 16 month period, the executor of the estate must pay the mortgage. They must pay the property taxes. They must pay all the utilities. Those upfront for probate fees that we talked about a few slides ago, they have to pay that out of pocket to get the probate going. The executor will get reimbursed for all of those fees, but unfortunately they don't get reimbursed until the very end when the probate is ready to close up. So it's a lengthy process. It's a costly process. It's a little bit of a burden to the heirs and the executor because they have to keep everything going and financially keep the property, you know, current on everything. So it's a little bit of a stress on some families when they find themselves in this situation, obviously. So obviously the goal is to avoid probate. You know, how do you avoid probate? You don't want to put your family in this kind of a position where, they have to pay upfront fees. They have to go to a court hearing, make a couple of different court appearances, and basically their family, their loved ones' assets are basically frozen until the court clears everything and allows distribution. So a couple of different ways to avoid probate. First way is to create a joint tenancy. So when you take title to a property, if it's a husband and a wife, which is the most common example, they would take a title as, Bill and Sue Smith, husband and wife as joint tenants, so that when either Bill or Sue passed away, the property would then go to the survivor. At that point, then the survivor of those two must think, gosh, now how do I protect my children? The option then could be, do they add their children on the title as a joint tenant so that this house can just keep getting passed on from generation to generation by the utilization of a joint tenancy grant deed? That's an option, not always a good option, but it is an option. The second option would be to just outright transfer the property to the children during your life. You decide that you don't want your kids to go through probate. You decide, well, let's just create a deed where right now, while I'm still alive, I gift my property to my 2 children, my 3 children, and then your children become the owner of your property while you're still alive. I've seen many cases where parents have done that. Children, for whatever reason, have turned on their parents and then start an unlawful detainer action to evict the tenant from that property. So there's good things and there's bad things about doing any of these other options. The third option, obviously the option which is the best, in my opinion, the best option for most families, is to create a revocable living trust. Revocable living trust is, go ahead and switch, yeah. A revocable living trust is a document that you create during your lifetime in which you transfer all of your assets into this living trust document. You no longer own your assets, your trust owns your assets. In your trust, you indicate at your death who will inherit the property. You can be as creative as you want in this trust. You can state that you want your children to inherit the property at a certain age. You can, maybe you have a total of 4 children and you only want to give to 2 children, and the other children you feel are financially stable, they have their own family, their own assets, they don't need the extra help. So you can choose to give to 2 children instead of all 4 of your children. You have so much liberty and creativity in these trust documents to do many different things. But the best part about it is that once you've done this trust and got it all set up, you pass away, there's no probate, there's no court, there's no statutory fees, there's none of the things that I just talked about that would happen in a probate. Everything transfers to those heirs by virtue of this trust document. So ideally, it's the best of the best situation to be in. People are afraid that when they do these living trusts, they feel they've lost control over their house or over their bank account because now they have it in a trust. Not true at all. You have full control over your assets while they're in the trust. You can sell them, you can sell the property, you can deplete all of the money in the bank account. You can take a trip around the world, you and your husband, and then come back and have not much left, but at least you had a great life, and whatever's left goes to your kids, and no harm, no foul by doing such a thing. It's your assets still, you control them. Like I say here, you are free to buy and sell assets, spend your assets as you desire. It's the best of the best. So people always ask, can you make changes to this trust? Once you create this trust document, are you like set with this? Maybe you decide you want to change something. You want to change the person in charge when you die, because maybe you feel a child is not responsible, and now you want to, have another child who's much more responsible, that developed much more responsibility over the years. Absolutely. You can make any changes you want while you are alive and while you are competent. That's kind of a crucial thing. The moment that you get Alzheimer's or some diagnosis from a doctor that you can't manage your own finances or your own decision-making processes, then you cannot make a change to the trust. But you can add beneficiaries. You can delete beneficiaries. You can remove any property. Let's say you sold a piece of property and now you've bought another piece of property. You can remove that old piece of property and add the new property into your trust. You can do basically whatever you want. You control the trust situation entirely, 100%. So probate versus living trust, which one is better? I'll let you decide, but I think by hearing what I've just said, obviously the living trust is the better alternative. Why? Why is the living trust the better alternative? You can make whatever changes you want. You can add beneficiaries, take away beneficiaries. You can remove trust property. You can add trust property. You avoid probate entirely by having a living trust. And you're free to do whatever you want during your life. Nothing is prohibiting you from spending, selling, saving, doing whatever you want just because you have a living trust. It's ultimately the best vehicle in which to preserve your assets so that when you pass away, your children will inherit from your estate without having to go to court, without having to hire attorneys, and without any legal fees whatsoever, just very minimum legal fees when you pass away. All right, next slide. So I thought I should just bring up some points about the joint tenancy, what I just talked about, that those are options, but sometimes those options are not good options. So yes, you will avoid probate by creating a joint tenancy deed, or in the case of just adding your children on the title, gifting it to them during your life. Yes, it does avoid probate, but there are so many problems that can arise by doing this. let's say you give the property to your children and they are married and they now get a divorce. Well, because they own that piece of real property during their divorce process, more than likely the party that's the spouse that was never on title or anything, they're going to try to claim that their community property earnings contributed to maintaining this house, keeping the mortgage going, maybe some major repairs had to be done, and earnings are community property. So it kind of creates a proportional interest in that spouse who's divorcing, that they may claim a portion of that property. And that was not the parents' intention when they gifted this property to their son or their daughter. A lot of times people gift these properties or add people on title to their home, and that individual child gets involved in some sort of an accident or some sort of a lawsuit ensues. And now there's a judgment pending on this child. And then that house now could be used as a lien could be put on that house, and potentially that house could be used in a way of satisfying a legal judgment. So that's not what mom and dad intended. Those are the kinds of situations that are kind of dangerous when you add a child onto your property, or make them a joint tenant to your property, because now they own a legal interest in your property, and anything that happens in their life is this property is going to be affected by it, and it could just backfire on what mom and dad's intention was from the very, very beginning. So it's not as advisable to do that. Obviously, the living trust is the better way to handle the situation. When you do a living trust, a couple other things need to be done at the same time. So obviously, doing this living trust or going through a probate process, it's not the best of situations. I mean, you're talking about death, you're talking about things happening in your life that you don't really want to think about, but unfortunately we do need to think about these things, because when things happen in our lives, and you need to do something legally to help solve or remedy that situation, at that point you may not be able to, because you might not have the right mental capacity to do this. So I always like to include in living trusts, it's like a whole package, that they also do an advanced healthcare directive and a financial power of attorney. So the advanced healthcare directive is a document that you create wherein you indicate who you want to make medical decisions for you if you're not able to make those medical decisions. God forbid, you're in a car accident or something really serious and you're unconscious. I just had a client at the beginning of last week who suffered from a seizure and was unconscious. The family found him on the floor and admitted to the local hospital here in Downey, and family was really concerned. He couldn't talk, he couldn't do anything, and the family was very concerned that he did not have a financial power of attorney, nor did he have a medical power attorney set up, and who was going to make decisions for him and what was going to happen. Make a long story short, that man recovered and totally, he's fine. But if he hadn't recovered, pretty much because of his mental status that he couldn't make a decision, doctor said he couldn't, you would have to go through the route of a court conservatorship. And a court conservatorship is a very costly matter, a very time-consuming matter, and you would never want to put your loved one through something like that, or your family through that. So by creating these advanced healthcare directive documents, you're declaring in the document, if you can't make a medical decision and you're unconscious, who do you want to make that decision for you? You're also able to indicate in this advanced healthcare directive, if you are hooked up to a machine and a machine is the only thing keeping you alive, do you want to be kept alive by a machine, or would you want them to pull the plug? That is the decision that you make. You indicate that decision on this power of attorney. The agent that you're appointing to make medical decisions for you is not making that decision for you, because you've stated on the document whether you want life support or you don't want life support. So you're not putting the burden on your husband, your wife in that case, or any of your children, because on the document, you're stating that you do or you do not want life support. So it's a real important document that should get done at the same time that you do your living trust. The next slide talks about the durable power of attorney for finances. So in this document, you create this document which indicates who will make a financial decision for you if you cannot. You got to make sure this is someone you know and you trust 100%, because they will have full access to your finances if you are deemed incompetent. If you don't get a financial power of attorney done and you are deemed incompetent, you become incapacitated, conservatorship has to be appointed for you, which I just explained, very costly, very time consuming manner, and that's usually done through the court system. So you want to avoid that conservatorship option. You know, the incompetency thing can start with simple dementia. We all get a little forgetful. We all forget a name or something like that. But once that starts to progress, and once a doctor has evaluated someone as incapacitated and that they're no longer able to handle their business or their finances, then they cannot make a decision. They cannot sign a legal document. They cannot sign a living trust at that point. They can't have access to their bank accounts. Banks will give you a lot of red tape at that point if you don't have a financial power of attorney in place for your loved ones. So it's super important that financial power of attorney gets done, as well as a health power of attorney gets done at the time that you're doing your trust, because that's when you are of sound mind. You know what you're doing. You can make those decisions very openly and very freely and very consciously. So you will be naming people that you know and that you trust. Don't always have to name children as your agents. Most people do, but you can name brothers or sisters, or maybe you have a friend who's an attorney, or a friend who's a physician. You might want to consider naming them as your agents because you feel they're very qualified to make those decisions for you. But always remember, it's got to be someone that you trust 100%, because they do have a lot of power to make decisions on your behalf. So you got to make sure you appoint the right people. The next slide, because I know people always ask, what are the fees? What do I charge? So I thought I would include it, and I would also indicate what I include in those fees. So a single person living trust is $1,225. A married couple living trust is $1,525. And all of these trust packages include the living trust, the will. If it's two spouses, it's a will for each of them. It's called a pour over will. Durable power of attorney for finances. If it's two spouses, it's one for each of them. Same with the advanced healthcare directive, one for each spouse. I prepare a new deed to your real property. The deed goes basically from you and your husband and wife as joint tenants, granting to the name of your trust is basically what the deed does. That gets recorded. So it includes the preparation of the deed, and generally speaking, the recording fee is around $25 for most counties. So that's why the fee is $12.25 and $15.25. If you have additional properties you have some rental properties or whatever, there is an additional charge to type up those deeds, plus obviously their recording fees. And some families have very large estates, and so a different kind of trust has to be created. It's called a bypass or an AB trust, and there's different fees for that kind of trust. But pretty much most families can get by with a simple revocable trust for those fees that are quoted there. Bypass trusts are not very common because they've raised the amount that can be allowed to be passed on through the heirs, and so the bypass now is not as common as it was a few years back. Okay, if you have any questions, since we're doing this as a video recording and not a live recording, you can certainly contact me. My phone number, I'll say it here because I'm not sure it's on I think it's on the next slide. Yeah, it is. So my phone number is right there, cell and office, and my email address is right there. Feel free to reach out to me with any questions, concerns that you may have. I'm here to help. I'm a good source to ask a legal question to. Been doing this now for, gosh, how many years is it? 25 or 26 years as an attorney and 28 years as a real estate agent. So I've encountered many situations throughout my life and dealing with clients and experiences. So I probably have an answer for whatever question that you may have. And I look forward to hearing from you. If you do have any needs or concerns, or your clients have any needs or concerns, be more than happy to help them. And I thank you for watching this video, and I hope it was informative.